I get a lot of calls from people who are involved in almost always residential real estate transactions, and they usually have a problem with the other side, the other party, or they might have a problem with the other side's broker, or they may even have a problem with their broker. Well, if you look at all of the California realtors forms that are used in these types of transactions, you'll see basically, I think it's at paragraph 22, that they have a dispute resolution paragraph that deals with disputes. And one of the nice things about the forms is that they usually start off by requiring people to mediate. And there's a penalty if you don't mediate, and that's basically if you go forward into either litigation or arbitration. If you didn't try to mediate first, you forfeit your right to get your attorney's fees. So this is an important thing. The forms are designed to have you sit down and try to work these problems out before you go too far into a litigation. Now, a mediation is where you sit down and you have a conference. Usually it's a confidential conference with the parties, and they try to work out a deal. And you have a third party, usually a former judge or a senior attorney, who tries to move the parties together toward a settlement. That's a good thing. Why? Because it's usually inexpensive, it's confidential, and here's the deal. It usually results in a settlement. Now, what is a settlement? A settlement is usually when both parties walk away a little bit miffed, maybe even a little bit angry, but they reached an agreement. And everybody goes, wow, that wasn't a pleasant experience. Maybe it wasn't, but here's the deal. You didn't have to go forward to litigation or arbitration, which is very expensive and very risky. And arbitration is basically an informal litigation that's held in a conference room where you have somebody who makes a decision in favor of one party or the other, and that's final. You usually have a right of appeal, but it's not that great in terms of being able to appeal. So people usually like to try to settle their differences before they go to litigation or arbitration so that they can avoid that type of risk where maybe they'll lose. And here's the beautiful thing. In the forms themselves, right, you have the right to either opt out of arbitration and go to litigation, or you can agree to binding arbitration. That's a good thing. But the even better part is that you can go for small items. When people are just fighting over small things related to the transaction, you can go to small claims court. And small claims court is really great for resolving disputes between people that are not really that large. And small claims court, you can bring a claim for up to $10,000 if you're an individual, and that's a good thing because you just go down to the court, you stand in front of the judge, you present your evidence, and the other side presents their side, the judge makes a decision, and you're done. And here's the great thing, right? The done part. After the judge makes the decision, you can pretty much say, okay, that's over with. You have a right of appeal, but most people take the judge's decision and say, okay, that's what happened, and they move on. Because here's the best part. When you're having your life and you have a family and you have your job and all this stuff, you don't want to spend all this time on litigation if you don't have to. And that's another great thing about small claims. So built into these real estate forms are all these different forms of dispute resolution, and they're made to basically resolve disputes so that you can get back to either enjoying your house or your family or your life, and you don't have to worry about litigating or fighting with other people for a long period of time. If you have more questions about these things, be happy to talk to you about your particular case in more detail. Thanks so much.